Okay, so we will go ahead and start with the Hornbaker case. If you want to go ahead and get started, we're ready.
I'm just trying to make sure this is.
Yeah, this morning, one of the attorneys kind of moved that around, so.
Okay.
And you can move the screen if you want. It
Out of your
swivels,
way, or,
it
yeah.
swivels or.
As long as my counsel isn't looking at my notes, that's fine. My glasses on.
Yeah. I'm sure it's going to just break the case wide open.
It will come as a big surprise, I assure you. Well, in any event, may it please the court. Thank you, Your Honors, for hearing this case today. I really do think this is a simple case. When you boil it down, the question before this court is really regarding one specific provision in an operating agreement, specifically Section 8.6D, which is the definition of the fair market value of the member's membership interest. And it goes on to provide, it shall mean the fair market value of the company, as appraised by an expert with the expertise to value the company and its assets. The parties disagree about the interpretation of that provision. Appellant's position is both of the terms of the contract and a common understanding of the fair market value require that a deduction be made based on the liabilities of the company when calculating the fair market value of the company. We respectfully submit the district court got it wrong in adopting the respondent's position, which contradicts the terms of the agreement and unsurprisingly creates a windfall in the appellee's favor. The parties do agree on a number of items. During the relevant time period, Mr. Hornbaker had a 1/3 interest in Wilderness Holdings, LLC. Wilderness is a holding company. The purpose of it was to hold both real property and personal property. And there's no dispute that the real property assets were encumbered by debt. All of those things are undisputed. We have a unique, at least I think it's a unique procedural posture. The district court directed the parties to file cross motions for judgment, a procedure and a motion that, as far as I can tell, isn't contemplated by the Kansas rules, and so there's no specific rule that speaks to the applicable standard. The district court didn't cite any such rule, but fortunately, the issue before this court is a legal issue. If a court's review of interpretation of a written contract is a de novo review, this court can be unaffected by the lower court's interpretation and rulings. That being said, I will spend a little bit of time talking about some of those just to help highlight our position. But it's pretty black letter here in Kansas that if the terms of a contract are clear, the intent of the parties is to be determined by the language of the contract without applying rules of construction.
Well, he's echoing.
I don't suspect time will be an issue today.
Okay.
Like I said, I truly do believe this is a simple issue, despite I'll carry on for as long as you'll let me. But nevertheless, before we got into the technological difficulties, I was just talking about getting into what is, I believe, to be black letter law in Kansas. When possible, a court must ascertain the party's intent from the four corners of the contract. In this case, it's the operating agreement, and they have to construe all provisions together and in harmony with each other, rather than focusing on one particular one and being critical without giving any thought to the rest of the contract. Under Kansas law, reasonable rather than unreasonable interpretations are obviously favored, and interpretations that vitiate the purpose or reduce a specific term in the contract should be avoided. Or if it results in what we frame in my briefing says is an absurdity, that interpretation should be avoided as well. Unambiguous contracts are enforced according to their plain, general, and common sense meaning in order to ensure that the intentions of the parties are enforced. What is the plain, general, and common meaning of the fair market value of the company? I don't think that there's any real serious dispute about that definition. The fair market value is the price at which buyers and sellers with reasonable knowledge of the pertinent facts and not acting under compulsion are willing to do business. And more specifically, we cited cases from, albeit other states, that provided when a company that is being sold, typically the fair market value of that company is its assets minus its liabilities.
So tell me, both parties had an expert appraise the property.
Yes,
And did the experts consider the liabilities in the appraisal of the property?
they did not. Both parties obtained what I'll refer to as what more traditionally are property appraisers, specifically to appraise the property that was being held by the company as opposed to the value of the company. In this case, it was a holding company, and holding companies do just that. They hold property. It wasn't open for business. It wasn't getting revenue. We didn't need an expert to value what, the income was and what the value was down the road. In this case, we needed experts to appraise the real property and the personal property. The liabilities, there is no dispute. It's reducible to a piece of paper, however much the note was originally versus however much it's been paid down. There has been no dispute. Appellees don't dispute that. That's why at least my clients focused on the appraisal to value the fair market value of the property. It's real property. It does require an expert. Same thing with the personal. But we did not have someone appraise the entire company because it was a holding company, and therefore we didn't believe that was necessary. And the operating agreement section 8.9 governs removal of a member. And the removal of a member is akin to the sale of that member's ownership interest. And it provides a couple of things that the removal notice must include. One of which, the main thing we're fighting about, is the company's fair market value of the member's membership interest, as defined in section 8.6B. Number two, a copy of an expert report relied upon in calculating the fair market value of the member's membership interest. And third, the written vote and consent.
I've got a question just to confuse me. In 8.9, what you just quoted, AI, is that what you just quoted?
8.9.
But little number one, it looks like. Well, it just says fair market value is defined in section 8.6B, you said, and then I don't think 8.6B has anything to do with this.
If I said B,
well, it does say B. But I think the provision we're really dealing with is 8.6D.
That's correct.
So this is it's just a Scrivener's error, but even in the operating agreement, it should have said fair market value is defined in section 8.6D.
I believe if it does in fact say 8.6B, that is.
Let's say like Senator Kennedy. I got it right here, biggest Dallas.
No comment. But yes, section 8.
Okay, I just wanted to clarify because when I was going through this, I'm going, man, I don't think 8.6B has anything to do with this. Okay.
Section 8.6D is the controlling provision to define what the fair market value of the membership's interest is. The section defines the fair market value of the company, not the fair market value of the company's property. Those are not the same things. Everyone agrees. It cannot be seriously disputed that a buyer of a company who has knowledge of debt encumbering that company's assets would not be willing to pay a price that fails to account for that debt. The district court incorrectly analyzed that issue as if it was the property of the company that was being sold as opposed to an interest in the company. Specifically, the language in the district court's opinion makes clear, quote, although net value might necessarily include consideration of liabilities, fair market value is the price a willing buyer would pay to a willing seller for the property. And in terms of the appendix, that's volume 4, page 99. It's the memorandum decision from the district court. The district court refused to acknowledge it was an interest in the company that was being sold, not the property. Adoption of the district court's reasoning would vitiate another portion of the operating agreement, specifically in to remove a member, one of the requirements in that 8.9 that we were looking at earlier is that the company has to negotiate the release of the removed member from his personal guarantee on the company's indebtedness. Based on the district court and the appellee's interpretation, he not only gets a release without giving any value, he gets paid dollar for dollar for debt that he is shucking off because the company was required to get rid of his personal guarantee. The debt remains with the company. He gets off free and clear and gets paid cash value for that. That, from our position, is an absurd result. And courts should avoid absurd results because they assume the intent of parties is not to create one. And Hornbaker implicitly acknowledges their interpretation leads to an absurd result. On one hand, he focuses on inopposite cases that stand for the proposition that courts can't rewrite a contract to save a party from a bad deal. So he's at least acknowledging that he's getting the better deal on this, while on the other taking issue with the characterization that Hornbaker will receive a windfall. He disputes that it's a windfall, but he says it's, they can't rewrite it for a bad deal. And to try and battle that, I'm not going to get into it, but he tries to mischaracterize the issue as the company kicked him out. We obviously take issue with that characterization. The company has the right to remove members pursuant to 8.9. They complied with that. The company disputes the characterization, and I don't think we need to get into it because, quite frankly, it doesn't matter for our purposes.
So what is the remedy that you're asking for?
We're asking for, we filed, one of our claims was a declaratory judgment. We're asking for the court to declare that the liabilities of the company have to be taken into account when calculating the fair market value of the membership interest under 8.9.
And when you go then and look at 8.6D, when it talks about appraised by experts with expertise to value the company and its assets, which I suppose is the property, has that appraisal been done? You said only the land appraisals.
Just of the, that's correct. The only appraisals that anyone has gotten done were of the property.
So wouldn't the remedy be, if you were to prevail, a remand to have expert value the company and its assets in order to determine the fair market value of the membership interest?
That would be a remedy if the court ultimately concludes that in order to comply with a notice of removal under 8.9, they have to come up with an appraisal of the company and its assets. There is no dispute that neither one of the parties obtained an appraisal of the company.
And why not?
Yeah.
Well, and
Since it does say in 8.9 refers this over to 8.6D, even though it said B, which makes it very clear there needs to be experts with expertise to value the company and its assets.
And in this case, the company holds assets, property, and the only thing affecting the fair market value of the property is the debt from the interest of the company. And like I said, that's not something that would require expert.
Even though it requires it here in the.
Well, I would say as required.
As appraised by an expert. It's
Yeah,
for experts.
and then, and that's one way to interpret it. If you go back to 8.9 and look at the three things that the removal notice must include, one of which, little Romanet 2, I believe, I'm not looking at, I'm just looking at my outline and from memory, says a copy of an expert report relied upon in calculating, not the copy or all the copy. It basically is leaving open the possibility that there can be a calculation of the fair market value without necessarily, in this case, appraising the company itself. Because
You would have us add language that says a copy of an expert report, or in print, it says S, so expert report or reports. You want us to add into that if there is one.
no, I think, I don't want any, no.
Well, I didn't think you'd really want to do that.
I don't want you to
because
add in
We're
any
not
language.
supposed to rewrite your agreements.
Correct. No, my point is, it's the way that I interpret that, it's leaving open the possibility that you may not have to necessarily 100% rely on the appraisal of an expert, especially in this case, because it's a holding company and didn't have business operations.
And that may, that may be great, but we have to deal with the plain language, and 8.6D clearly says it's supposed to the fair market value of the membership interest, which I think you're making a good distinction, but the property may be part of that, and not all of it. But it says the way you calculate that is by an appraisal by an expert or experts to determine that. So it seems like perhaps you both did this by agreement, but you've bypassed that plain language.
Certainly, based on the court's interpretation, we did not obtain.
I'm just looking at the plain language. I'm not really interpreting it either. I'm just reading it to you.
I understand that, Your Honor.
So when you sent the buyout notice to Mr. Hornbaker, you sent an appraisal report saying it was worth 2.27 million plus the personal property.
Yes, we said it being the real property was worth 2.7 million plus whatever the value that was ascribed to the personal property.
And did that notice contain anything about existing debt?
The notice identified that we were subtracting the debt on the real property to come up with the value of the membership interest.
Okay, yeah, I misread that. All right.
Okay, you're at the end of your regular time. You still have your rebuttal time. Did you all have any other questions before he gets to rebuttal?
No,
Okay,
Thank you, Your Honors.
thank you.
Thank you.
Mr. Reed?
Good afternoon, Your Honors. May it please the court, Brett Randall again for the appellee, Connie Hornbaker. And I would submit this is not a valuation theory case. This appeal is a contract enforcement case. And what do I mean by that? The operating agreement contains a contractual definition for the fair market value of, in this case, the removed member's membership interest. And as you've read in the briefs and as you've heard today, section 8.6D, B is a typo in the agreement, Your Honor. You're correct about that. Section 8.6D defines fair market value of the member's interest as the fair market value of the company as appraised by an expert with the expertise to value the company and its assets multiplied by the member's percentage interest. And that as appraised by an expert is the critical language in that provision as concerns the issue on this appeal. Why? Because those expert valuations are what the parties contractually agreed they would rely upon to calculate what the removed member will be paid, nothing more and nothing less. So under this contract, once the company provides its appraiser's report or its expert's report, they were free to choose whatever expert they wanted to choose. Once they provide that report, then the removed member, Mr. Hornbaker, then has an opportunity to provide his report. And under this provision, you just average those two. And since they're equal members, you divide by 3. What this provision does not allow is for one party or the other to make adjustments to those appraised values that are determined by the experts. So for example, the company is not allowed to take its expert's valuation and then deduct liabilities or debt or anything else. Likewise, Mr. Hornbaker is not allowed to take his expert's valuation and add value for other things that he thinks should be included. Intangibles, goodwill, whatever the case may be. The contract takes valuation out of the member's hands entirely. And so that's what I mean by this case is not about general concepts of business valuation or how a company might be valued in some other case under some other circumstances.
Well, then that was what I was trying to get at on my questioning co-counsel, but I don't want to say we don't care, but the reality of it is what the ultimate answer is seems to not be the issue before us. Partly that's good because we're not mathematicians or we would have went to med school, but we do have to follow the plain language. And so wouldn't the appropriate remedy be to send this back and to have experts do it? I don't know what they're going to answer, but to have experts under 8.6D do what they're supposed to do and then see what the answer will be.
Well,
Because it seems like both of you want us to replace our judgment. Well, one wants us to just affirm what was done below, and I think you would prefer yeah. And then the other would like us to replace, our judgment for what the contract would be.
well, I understand the question, but 8.6D defines fair market value by who determines it, not by any particular methodology. So it says it's the fair market value of the company as appraised by an expert. So they hired their expert. They hired a property appraiser. And they didn't hire an expert in business valuation. They could have done that. It's not even limited to one expert. You'll see in the provision there, experts, plural. So that's the path they chose. And then when Mr. Hornbaker receives that notice and it attaches their property appraisal, then he has an opportunity to provide his own so there can be average. Well, it's an apples to apples comparison. So he goes out and hires his own real property appraiser. We didn't initiate the process to remove ourselves.
It seems like nobody's determined the answer under 8.6D. The answer that we're all looking for is what is the value of the company and its assets multiplied by the membership interest. That will then give us the fair market value of the membership interest.
Well, I think, Your Honor, respectfully, under this contract, the appraiser, the expert hired by the appellants, determines what the fair market value is. And this, as counsel mentioned, this is a holding company, it owns real estate. So it could be that this appraiser, this expert looked at it and said, well, if someone wants to buy this company, they're going to buy the real estate. So we're going to value the real estate. They're not going to buy the equity or purchase the equity and then assume the debt. It's a property holding company. They're going to buy the real estate.
So are you saying that they're the ones that had the responsibility to get this done under the contract, or they had to submit their number? They submitted their number, and that's what they're bound by.
That's
basically, they didn't give any other number, and they would have been required under this provision to provide what they were relying on. And that was the only thing they provided.
That is correct. And that is what the district court found, that the provision requires reliance on experts. They chose their expert. They hired their expert. He came up with a valuation. He did not consider liabilities. There's no methodology that's specified in this provision. The appraiser could have chosen any methodology.
That same, because you were supposed to do one of your own, and so you just matched the same methodology that they used.
Correct.
And what, I don't have the record in front of me, but what was the difference?
It was probably,
My colleague says.
what was the answer?
About $1 million, is that?
Yeah, I think that's about right.
Okay.
Yeah.
So they took that difference and averaged it.
Yeah, they took the two appraised values, averaged those and divide by 3.
All right.
And that number is whatever that number is.
Right.
And our point all along has been, you don't take that number and then make adjustments to benefit whichever side of the equation you're on. The contract by intent takes that completely out of the member's
So when
hands.
and again, maybe this is in the record, and I made a big deal about how we've read the whole record, but so when they submitted that to you, did they submit a letter that says, here's our number that we're presenting to you
Yes,
under the contract?
Yes.
Here's our number.
yes, the contract requires a notice. They did send the
That's
notice.
in the record.
They attached, yes, it's attached.
Did
to
they
the
identify it as a fair market value of membership interest or as a property appraisal? That's what I'm
petition.
trying.
In the notice or the attachment to the,
Either the notice or when they gave you, it was their first obligation to have the expert look at it. When they gave you that expert report with whatever documents it was with, did they identify that as the fair market value of the membership interest?
going from recollection, I think they used the terminology that was in the operating agreement.
Okay, and that's what your expert did as well?
Yes.
Okay.
Well, we sent a letter that said attached is our, whatever the term is for the notice we're supposed to provide, and attached is our appraisal report, and the averaging of the two equals.
So both parties believed that they were submitting what they were required to submit under this section of the contract.
Yes, yes.
So if there's a mistake, it's mutual.
Well, I could see why you would say that, but I don't necessarily agree with it. Like I said before, we're not the ones that initiated the process. We received a report from the appellants, and then we provided our own, so those two could be averaged. And so what the appellants did is they They obtained the appraisal and then they provided that to us, and then they did their own math equation. They
Which
didn't
was
farm
not
it out
an
to an
expert
expert.
report. It was just
No.
their own.
They didn't farm it out to an expert to say, okay, here's what the real estate's worth. Now tell us what the company might be worth with that real estate value. They just decided that they would deduct a third of the mortgage debt from that price.
Okay, one more question for me that shows that I haven't read the
We thought we read the pertinent part of the
pertinent
record.
part of the record, but when I see numbers, I gloss over. So what, as compared to the value of the company that was provided after this process took place, the averaging, that number, how does that then compare to what the liabilities are? What's the windfall that they're alleging your client got?
I believe it would be our share of the debt that Mr.
Right.
Hornbaker personally
Which would have
guaranteed, which
been-
was about roughly $300,000.
Okay, thank you.
And he would,
That's 1/3.
Yeah, the 1/3.
correct. It might have been like 300
$310,277.83.
I got the 310.
There
out.
you go.
There's the
There
number
you
for
go.
Okay, I just want to kind of put this all in perspective
Yeah.
in my mind.
I appreciate the question. So let me jump ahead to this use of the ordinary meaning of fair market value. And what they're essentially asking the court to do is to equate the meaning, what they consider the common meaning of fair market value of the company to the net value of the assets. And that term is not used in this section 8.6D or anywhere else in the operating agreement for that matter, nor is book value. But that's what they want to equate fair market value to. And if that's what the parties intended, they could have very easily have drafted such a provision. In fact, the Kriegel case that's cited in their brief provides an example of an operating agreement that uses book value as opposed to fair market value. And secondly, the fair market value of, the common meaning of fair market value or the common meaning of any term doesn't apply when the contract contains its own definition as here. And here the contract ties fair market value to the expert appraisals and then requires the parties to accept that number.
I was trying to find where I got that language about mistake when I asked you maybe. And in paragraph 15 of Judge Vano's order, I think he was the judge, wasn't he? Yeah. He refers to the notice of removal mistakenly failed to account for Hornbaker's 1/3 interest in the company's equipment / personal property. And it goes on from there, the total ownership interest, which Shin appraised at a market value of 120,000, whatever. Is it your position there wasn't a mistake?
I'm sorry, I was trying to find that language in the judge's order.
Yeah, I'm looking at his order memorandum decision on page 4, paragraph 15, where he seemed to indicate there was a mistake.
So the memorandum decision that I'm looking at doesn't have numbered paragraphs, so you and I might be looking at different documents, Your Honor.
Let's see. Oh, that's your joint stipulation. It's attached to the memorandum decision. So page 4, paragraph 15 of the joint stipulation of facts for motions for judgment. Which it sounds like maybe you both did agree there was a mistake. Maybe that is where I got the mutual mistake.
Yeah, so what that relates to is the initial notice that we received from the appellants failed to include Mr. Shin, their appraiser's valuation of the company's equipment and personal property, and they corrected that mistake.
Okay.
So that's what that relates to. So I'm sure I'm close to time or over time,
A little bit.
but let me address this.
Said it's a nice day outside. It's up to you.
We don't penalize you for anything.
Sure. Let me just address this windfall issue briefly because that seems to be a focus of the appellant's brief. First of all, we dispute that Mr. Hornbaker received any windfall. Appellants are now the sole owners of this very valuable piece of real estate on which exists a very nice lodge that Mr. Hornbaker constructed as a general contractor. He no longer has the use and enjoyment of that property. He no longer has the opportunity to realize the gain from appreciation of the real estate. And he no longer has any right to the future income from the property. I would dispute counsel's statement this property doesn't generate any income. There could be hunting leases at one point in time. There was Airbnb, short-term rentals on the property. It has the ability to generate income, and Mr. Hornbaker has been deprived of that because he's been removed from the company. So the appellants have created both immediate and future value for themselves by removing Mr. Hornbaker, even if that did require them to assume Mr. Hornbaker's portion of the debt. And even if that were considered a windfall by some, of course, Kansas law does not allow courts to rewrite contracts to eliminate perceived windfalls or to make a better deal for the parties than they made for themselves. So bottom line is Section 8.6D is a simple provision that requires the parties to rely on outside expert appraisals. That was done. You average those and you divide by 3, nothing more, nothing less. And we would ask that the district court be affirmed.
Thank you.
Thank you.
I don't.
Rebuttal?
Thank you, Your Honor. Okay, I might jump around a little bit because I want to address some of what my co-counsel just discussed. But first, and I know I mentioned this at the outset, debt is debt. We didn't need an expert to value the liabilities that were encumbering this property. If
You might have needed it, but explain to me why, if the contract says that this is how we figure this out, if we're valuing people's property, that you will submit this valuation based on the definition of valuation in D, 8D or whatever D it is.
60.
Okay, it's D. And you give them a letter saying, okay, this relationship is terminating. Here is that value in D. What allows you then to add to that later? Or, I mean, it seems like am I getting this wrong? You give them an amount, they give you an amount, and then you say, oh, wait, we forgot to include liabilities?
Yeah, no, and to just correct the misinterpretation and whether I misspoke or my co-counsel did, the first notice of removal, the mistake was that we had appraised the personal property. We had an expert appraise it, but it wasn't included in the notice of removal that we initially sent. The opposing side notified us. They said, hey, you didn't include personal property. We said, that's our mistake. They didn't say you didn't appraise the value of the company. They didn't say anything else about any other deficiencies they felt were with our appraisal. But in connection with the notice of removal, initially, from the very first point, it provided the company's fair market value of your membership interest is equal to $446,388.84. Paren 756,666.67 minus 310,277.83, which is the debt. So from the very beginning, we have not been hiding the ball about liabilities. That was included in the first notice of removal that we sent. And in terms of
What they sent back, though, was something that did not include this liability either.
they sent back something, they objected to us minusing the liability and attached their expert
That when
appraisal. They did.
responded.
They did. And the idea, so if the, and why didn't we? Quite frankly, because my clients didn't believe that it was necessary. And if the court disagrees, neither party complied with Section 8.6, and there was no appraisal of the company itself. Both parties just did the property. And in fact, and that's precisely what the appellee asked their appraiser. They didn't ask them to appraise the company. They asked them to appraise the property, and that's present in.
That's what they were handed. I mean, I can understand that position too. That's what they were given to compare to. Why would they present something to you that would not be to their benefit, I guess?
Well, if they thought that an appraisal was required that evaluated the company and not just the property, which they're now arguing here, several years later, then I would think that they would still be obligated to comply with Section 8.6D and 8.9. And, it's not what's good for the goose, it's good for the gander. That's not the way contracts work. We either both did the right thing or we both did the wrong thing.
But aren't we bound by what you both did?
you are bound by, I mean, those are the facts. I mean,
And you both went out and got an appraisal for the property
correct.
and submitted that appraisal as a valuation for the company.
Well, we submitted it as an evaluation as the property, and in the fair market, in the notice of removal, we identified what we believe the fair market value of the membership interest was, impartially in reliance on that appraisal of the real property. But we always, in all of our communications pursuant to 8.9, we always communicated that what we believe to be the fair market value of the membership interest under 8.6D included liabilities. Did our appraisal say that? No. But all of our communications did under 8.9. And with regard to net value and book value, you know, I think I'm probably even at the end of my time as my watch is vibrating in any event. But the reason it doesn't say net value or book value is because it says fair market value of the company. I don't think anyone believes that someone will buy a company without accounting for any debt, especially if those people are being released from the debt. Therefore, as requested in our briefing, we would respectfully request the decision of the district court to be overturned and to be, judgment entered in appellant's favor that liabilities must be taken into account to value the fair market value of a membership interest under 8.9. Thank
Thank you
you.
very much. We appreciate your argument. We will take this matter under advisement and issue a decision as soon as possible.
Thank you.